thank you guys for coming. We have some amazing guests. Karen is not here because she is leveling up her short-term rental in Tennessee right now. So super excited for her to get a little more cash flow on that investment. But just a little introduction for me for the video. I'm Amy Weisbender. I just saw someone walking by. Maybe. No? All right. And so, a little bit about me. I'm a cheer mom. I'm a dance mom. And since Kelly was talking about my dancing skills, I'm going to show you some dance skills. Also with Berkshire Hathaway, Colorado Real Estate. I'm a real estate investor. I have 13 units across 3 states. And that's with my husband. He helps me with that as well. And then my passion it's my new passion. It's not new, but I've named it, is to help blessed baddies achieve their dreams in real estate. So how do I do that? And Karen is my partner in crime on that. Number 1, we have these free real estate education classes. We are getting ready to roll out our next year. This will be our 4th year doing these classes, so we're super excited and we're expanding. We've got a couple new agents, Dusty being one, joining our crew, so we can even go further, span across more people. And then we also, Karen and I do goal setting consultations. So if you need to document and set a plan so you actually do something instead of just keep learning about how to invest in real estate, we have that as well. And then the third thing we do is we bring in baddies like Brenton and Grant here to be part of your team. So you are going to succeed the most if you have a team around you. And Kelly's also a good team helper as well. But she'll get introduced in another class. So first, I'm going to introduce Brenton. I've got a speech about you, so you don't have to introduce yourself.
Okay, go for it. Go.
So Brenton
I'm a fatty, not a baddie, because I had Chick-fil-A for dinner.
He's a fatty. But Brenton is a very experienced multifamily commercial guy, is what I'm going to say. His family owns over 900 units in LA, so I think if he knows real estate, he knows real estate from that. Also a amazing, big-hearted guy who loves to help others. Obviously, he doesn't need to work, but he does that out of the kindness of his heart to help agents like myself, clients like you, to better yourselves as investors. Did you good? Anything else you want to share? Oh, you're also an awesome dad. 2 kids.
Yep.
And then Grant, who will be coming up here, you can come up and join us. So
later.
you want to hear my speach first.
Yeah,
so
who is this guy, Grant? I want to know.
Grant Vandriot, I say that right?
Perfect.
Is a highly intelligent attorney, is how I would classify him. Knows a lot about real estate. Used to manage 2,000 properties for real estate, so he knows how to manage properties. He's also very creative. Understands tax law really well, and he's also got a big heart as well, which is why he's a baddie or fatty or whatever you want to call it. He's not a fatty, but he is an awesome. He's a tallie. He's a tallie, that's for sure. But he's also big-hearted, awesome role model for his family, his community, and so without further ado, I'm going to welcome these wonderful Tallie and fatties.
Great job.
Awesome. Well, I'm going to put on my glasses because I'm also an oldie, so it's getting harder. But so I know Amy wanted to have us talk tonight, and we're going to make it more conversational style. So I don't have any boring PowerPoint slides. I don't have any flashy images. It's just more about just diving in, getting creative on exit strategies. So really, the whole point is when you go in and invest, you got to figure out a way out. What does that look like? My family, we're what's considered legacy owners. And so we have, what Grant does, we have multiple trusts and how that is funneled through on depending on structures of properties and how we take title in them as well. So it's something to think about day one when you acquire property and setting that right foundation. And so I'll let Grant talk more on the legal side. I do want to preface that I am not a CPA, okay? I don't play one on TV. I'm not a tax accountant. I'm a real estate broker, okay? So Grant will keep me honest. He'll let me know when I overstep my bounds, because I tend to sometimes, just because of my family background and the creativeness of what we've done. But when you have someone that wants to sell, kids don't want to take over the property, lost interest in the property. There's many reasons why people sell, right? Life's changed, but I think the one common goal is, what do I do with this money where I don't have to pay taxes? How can I reposition it? Especially in the multifamily business. So multifamily is probably your most management intensive, right? And that's typically where you're going to get your highest returns from, because it's kind of more active income versus like a triple net lease. Let's say like a Home Depot or a Lowe's or a Walgreens, right? It's a freestanding building perhaps, and you would own that building, and it's long-term leases with potentially zero landlord responsibilities. We call that a coupon clipper. You don't go to the mailbox anymore, but we'd say you just go to the mailbox and get your check type of investment. Where I had multifamily, I got this going on and this tenant's not paying, and it's a little bit more active and a lot more strategy behind it. So we've all heard of 1031 exchanges, right? 1031 exchange is a great tool on an exit strategy, especially if we're going from multifamily out. So if you're kind of aging out or just don't want to be involved, want to kind of check out a little bit more mentally, you're getting tired, and going into that triple net lease, going into something that's a little bit less management intensive. I've had a lot of clients do that. They'll go in and start buying up Walgreens and Home Depots and things like that. They'll take that money and exchange it in there. You can exchange into real estate funds, right? So a lot of times funds can have a portfolio of properties. It could be a single property. They could be structured as DSTs, syndications. There's a lot of different wording for funds. And so you can take 1031 money into some of those depending on how they're structured. And so as you research funds, you want to make sure that they have the structure in place and the timing and the loan amounts that would check those boxes for 1031. If you're doing a 1031, you can still take cash out in that process. So if you're not as liquid as you want to be, or you want some cash to upgrade a home or whatever, you can take money out, but you are taxed on that as boot. Okay? Don't think you have to exchange all of it. You can exchange a portion of it, but the portion you don't, you are going to be taxed on as boot. So always consult with a CPA. I had a lot of clients saying, well, it's either I have to cash out or I have to exchange. Like, no, we can offset some of that and go into other properties and stuff. We just have to get a little creative with that. There's always tight time frames associated with 1031 exchanges. I know Grant said you can exchange into 721s.
Mm-hmm.
I'm not familiar with 721s. So could you explain a little bit more on 721s?
Yeah, so just to clarify, when you take money out of a 1031, you're not necessarily paying taxes as boot. Boot and taxes and the draw are three separate things.
True.
When you take the draw, just make sure that you have a tax attorney that has a reason for offsetting that income so that you don't pay tax, right?
Right.
So the assumption is by default you're going to pay tax on that because it would be ordinary income or long-term capital gains, and you might have a recapture problem if the depreciation has been carried for a long period of time. So it wouldn't necessarily be boot. Boot is more like when you fall into a treasure chest of money. you have to report that, and
Right.
that would be boot. You just stumbled upon riches. And then as far as the 1031s, the funds, funds can have syndications, DSTs, and 721 REITs. The major distinction, I'll get up on the camera so you guys can, so your other people can see.
Go ahead, grab the other
Just
chair.
sit down.
Pull it over.
So your
Stay a while.
your fund is going to have DSTs, which are typically 1031 possibilities, your REITs, which are 721s, and your syndications, which are another type of stock. The major distinctions here: a DST is a Delaware statutory trust. It doesn't have to be a Delaware trust. It can be any kind of statutory trust. California is a common statutory trust location because there's so many deals out of California. Not very efficient, but still very common. Wyoming statutory trusts are pretty common, but Delaware is the most common. That's where it started. The idea with a Delaware statutory trust is the trust owns it, and each of the beneficiaries by statute are title owners. And that creates a really cool opportunity because if you're a title owner, let's say there's bankruptcy in the management. Worst case scenario, the title owner gets ownership of the property. So what? The downside is very, very limited, right? Whereas in a syndication or in a REIT scenario where you're holding stock to real estate, if there's a bankruptcy in the management, you own nothing. You lose 100%, right? So when you go from a 1031 to a 721, what you're doing is you're trading your security for fungibility, right? You're going from, in a DST, you're locked in, and there's tricks to get around it, but you get into the income period. Let's say it's a 5-year term. You're a title owner, you have to stay in it for the full 5-year term, you can't get out. There's some tricks again to being able to maneuver, but when you go from that 1031 environment into a 721, you're fractionalizing your money and you're able to distribute it and diversify across many different industries. So yes, there is a risk that if the management goes bankrupt, you lose everything, but you get to distribute it across oil fields, across medical investments, across industrial, warehousing, multifamily. You're so diversified that, so you might lose a little bit. Your overall income can go way up. And that's another tax deferred way of getting into and out of real estate. So you can go from, what we're talking about here is you can go from your Roth IRA into a DST with a 1031, and then go from that 1031 DST into a 721, and all the while diversify and reduce your overall active participation. That makes sense?
It
So
does
you
make
just have to, but you have to find, you would find someone who's already got a 721 set up, right? Like a fund set up.
You can set up a 721.
But then you're not really reducing your workload if you're setting up yourself.
Right.
It all depends on the goal of that client, right?
Yeah.
I mean, everyone sells for different reasons. Some of the common ones are that you're just aging out. You know, what I run into a lot. They're gone. The kids don't want it. What do I do with the money? You know, and how can we not pay all those tax?
Yeah.
And right now, I would say that's a major thing to pay attention to. People are aging out and they don't want participation. And many of them are sitting on a lot of wealth, and so they actually want to delay their income over a period of years. So you're going to set up annuities when you're trying to buy a property on a seller carry. You want to very much pay attention to the interest of the seller as you're trying to structure the deal. So if you're trying to be a buyer, you really have to start asking about the interest of the seller, because you're not going to get to a mutually beneficial scenario unless you really understand both sides.
And that's always hard for us, right? Because if you have other brokers involved, they don't want to divulge the motivation because it could impact.
Yeah.
Right?
So,
Yeah.
you know, I have an argument against that, right? A lot of real
Yeah.
estate brokers, they feel like they're not allowed to reveal the motivation yet. What's the number one task of a real estate broker? It's to get the most money for
Yeah.
your client, right? And tend to their needs. Well, if their
Yeah.
needs require you to have an interest-based negotiation, and they may not know this, but by way of example, if I were to task Brenton with, I have a basket of goods, a basket of oranges, and I told Brenton, you need to sell this basket of oranges for the most amount of money you can possibly get. And then I have one buyer over here, buyer X, buyer Y, and buyer Z, okay? Buyer X is gonna offer $100 for the basket of oranges. Buyer Y, 150. Buyer Z, 200. Who are you gonna sell it to? As a real estate broker, you're gonna choose 200, right? Wrong. If you're not asking why, you're missing the entire point. Okay? So, why are you buying the basket of oranges? You wanna make,
I wanna make money.
you wanna make orange juice,
Oh, okay, I make orange juice.
right? And you wanna use the rinds to make insecticide. And you wanna make pie or oil or whatever. Well, if it were me, I would sell the same basket of oranges to all three. Does that make sense? And you can only get to that if you ask about the interest. What are your interests? What are your motivations? If you're not asking that, you're not getting to the ultimate benefit to all parties.
No,
That was a good example.
I feel like having an orange.
Yeah.
Maybe some orange juice.
Screwdriver?
Yeah. You know, and this has come up many times. Today I had multiple people call me looking for creative documents. And it's funny, by the end of the call, I'm like, just tell me what everybody's interests are and I'll put it together. Right? So talk to the seller, and some of these are VA folks that have extremely low interest rates and they want to have an assumed note for the buyer. And usually there's a perceived notion that if the seller finances, so the seller typically wants to get that debt off of their debt to income ratios for the long term, right? So they're going to put a time horizon saying 3 years into this deal, I want out. And so I'll seller finance this on the condition that you refinance me off so that I can go buy more real estate without this anchor is, within 3 years. That's a major fallacy. Because if you talk to the lenders know that if you have a performing note where third party is obligated to make those payments and they have performed, you can supplement your loan package and say, yeah, I have this on my debt to income ratio, but I also have income. And as we know, with income, you have a debt to income ratio. The more income you have, the more debt you can take on. So by having that debt with performing income, you can get more debt.
Yep.
It does you good to have that in service. And it's actually hurting the seller to have that person pay it off. And once you have that conversation, you get into, like what happened today was, we said, we want to encourage the buyer to slowly be more incentivized to refinance it. Okay, so now we're going to talk about an adjusted rate on the mortgage that increases 1% a year. So it'll be a 3-year term, and then after that, each year, the interest rate will go up by 1%. Now we've turned that into a profitable annuity for my seller. And ultimately that's what they were after, was lowering their taxes, but letting a friend take over a low interest mortgage.
So are you getting a lot of seller to refinancing
2 today.
calls? 2 today?
Yeah, 2
Okay.
today.
And that leads us right into the next subject, installment
Alright.
sale, right? It's a
Yeah.
great way.
Actually 3 today. Now that you said installment, I had a commercial building, where we were trying to do creative, and the issue was how to get a larger down payment out of the seller. Okay, so you typically hear about seller financing debt, but there's 2 sides to that. You have the debt side and you have the equity side. Just because a seller is a seller doesn't mean they have to abandon all of their interest in the deal. They can stay in the deal. So in this particular one, I said, why don't you structure the scenario if you need more equity in the deal and the seller is willing, then say, why don't you just buy the building and let the owner carry the land in the deal as an equity contribution, and then you can structure a contract to buy the land out later. And in that way, when you go to the lender, you say, well, I've got, if it's a $5 million deal, I've got $1 million worth of land, so my 20% is coming into the deal as a down payment. Deal's done. You see? That's a zero debt, 20% equity carry. So it's a joint venture between the seller and the buyer.
Installment sales is a great way, or even like that. I mean, that's a
So
little
explain
bit
this
more on the
installment
complex side.
sales, like, explain that for the video and people in the room.
Explain what?
Installment sales.
So installment sales, basically, seller carried financing, seller carrying the note. And I've done a lot of owner carried financing in my career. It's a great tool. I actually sold an office building up in Evergreen, and the sellers didn't need the money. They were just done with the building, and was able to put a phenomenal deal together on that with like 15% down and carry the note back for 7 years. There was one rate adjustment 3.5 years in. I mean, when you get into installment sale, it's a blank sheet of paper. You can structure it however you want, or you have an attorney structure it, but your clients can structure and get as creative as they want. I have a friend that buys a lot of apartment buildings up in Washington. He was 18 buying apartment buildings. He's got 300 units now. He's 22, 23. And he did it all through owner carried financing. And he would call sellers that have owned properties for 20 plus years and take them out to coffee, and then he eventually, over a couple years, sometimes sooner, convince them to sell them the property on an installment sale, owner carried financing, and it would be interest rate would be 1 point under the cap. And as his rent goes up, his interest rate would go up. So every year they would adjust the rate based off him, and he would make a point spread on it to a point of then he would cash out the seller. But it was a great way to offset some of those capital gains and be relinquished to property management. And then if he defaulted on it, they would foreclose and get the asset back, right? The asset is the collateral. And so he was rehabbing it and putting money into it, and he had some other investors and then he would cash them all out. Guy was 18, living at home, mom and dad, buying apartment buildings.
Is he still doing that with the current interest rates?
He's still doing it, yeah. Yeah, it was interesting to see him do his first conventional deal ever with conventional financing. But he does it on smaller buildings, he's not buying, 50 unit buildings. He's buying, 8, 10, 12s, now he's up into 20 and 30 units. But he's able to leverage those in exchange. But, on the seller side, it's the creativity, right, to structure that. So if they don't need a lot of money down, they don't take a little bit. They only take a little bit of a down payment because they're only taxed on the money as they receive it. And that interest helps offset any of the capital gains.
So the win for the seller is a reduced capital gain, tax. and
Management responsibilities.
But you gotta ask, you have to ask the seller. Like, I can tell you this week, we've got a deal going. The motivation is, I don't wanna mess with my brother. That's the whole deal. That's the whole reason that the seller is selling, is I want this out of my name so I never have to talk to my brother, right? I have another transaction that's going right now. The seller doesn't care at all about the money. The seller wants to do seller financing, but then give the entire amount of the loan and the authority to service that loan to his church. He doesn't want any of the money ever. He wants the deduction for the entirety. He's gonna donate the entire amount of the owner carry.
Yeah.
So do they have you have to have a certain amount down, or they can say whatever they want?
You have to understand that there's there's so many people that are aging out of this economy, and there's very few people that are aggressively trying to save what these people have built their entire lives. In almost every estate plan that I have put together, there's this trauma that the kids don't want to take over the parents' business under any circumstance.
Yeah.
Right, so you have the old man or the old woman who's put 40 years into this, building this whatever, and nobody who's going to carry on the legacy. If that's the motivation, then the way you get the deal is you put it out there in a way that saves their legacy, or at least saves face. So there's different motivations for every single seller. It's not, you can't just categorize every exit strategy as money or tax deferral or, you know, turning into an annuity or profit based. No, there are so many different motivations for why people do these types of deals. You just have to continually ask what exactly and why. Why, if they say, I don't want to talk to my brother, ask why. Okay, he's a megalomaniac. He's gonna throw a wrench in my life and I just want distance. Whatever that answer is, they'll tell you, preferably, hopefully. And a good broker, in my opinion, owes the duty to their client, first of all, to ask for permission to dig and try to find that. And sometimes brokers buffer those conversations, and if it's just about the money, that's a great scenario, but in a lot of these situations, it's about something bigger. Conservation easements is another really big motivation. Lots of folks come to me and they're like, I've got this big open piece of land and I don't ever want to see a Walmart here. Make that happen and it's yours. Right, so really.
I don't know, are you
broad
guys
variety.
familiar with conservation easements? The conservation easements, out by me, because I live on acreage, we see that sometimes. It could be, you could have 100 acres and they put a conservation easement on 80 acres of it, or all of it, or portions of it, or sections of it, and it's basically, it depends on how it's drafted. You can't build, or you can only rebuild the structures that are there, right? Depending on what's there, and it literally will come on a survey. This is all part of a conservation easement, and there's usually tax incentives with that too, depending on what it is. I've never structured one or been involved on the structure side, but
I did one for the Navajo tribe, and their main thing was, I don't want guns. You can hunt, but you need to use traditional native hunting methods. That was their motivation. They would sell to anybody who would honor that.
yeah.
Pretty cool.
Yeah. I've even heard of no alcohol.
Yep.
Yep. You know, can have it, but you can never have or sell alcohol on this property. You know. But yeah, those are.
So it sounds like, just to kind of summarize, like there's exit strategies can be super creative in whatever you really want. So it's really understanding if you're ready to get out, like why do you want to get out?
Understand why, and
The why is the most important thing. That's gonna determine how you drive it.
there's lots of attributes. So the timing of ownership, the timing of title delivery, the timing of your principal balance being paid and how much, that's part of your amortization schedule. That's just like a timing question. And if you look at each attribute of the sale and you view it as a sliding scale, when you're asking why, you need to be looking at each attribute of that sale and trying to figure out where both sides are going to be most positioned to benefit from the deal. And it's different with every single deal. There's some phenomenal new equity sharing agreements that are another exit strategy that you can get into, where you take partial ownership right away and incrementally get the person out of their home. That's a phenomenal setup for the investor.
Explain that a little further.
So equity sharing is a way to provide a cash injection to the seller without affecting their negative cash flow. So you do a 0% interest loan to the seller in exchange for a percentage of title ownership.
Okay.
And then you typically carry back a rental interest because now you're a title owner. So let's say I purchased 25% of a piece of property. Well, IRS is gonna say the person living in the property, which would be my seller, owes me rent, fair market rent for 25% of the property, as opposed to an interest rate. It's not a loan. We've gotten into a joint venture where I'm incrementally buying him out at 25% per engagement, right? So that he has a cash injection. I take a long position on the future of the home, 0% interest, so he doesn't have to deal with going into foreclosure on his first. So he'll stay in the property a lot longer. I get to ride that on a minimal investment, but I get the benefit of the appreciation on the entirety. So it's typically a much better rate of return than your typical note.
Yeah. Is there anything for getting out, and using the money to pay for college without being taxed on it?
So like you were talking about your 529 plans.
Like selling real estate that will have a significant capital gain because they've been owned for so long, and using that money to pay for school, college, without getting it taxed along that process that you're aware of?
You could put it into a trust that funds a 529 and then through the 529 get educational access. I don't like 529s because they limit where you go to school.
Mm-hmm.
I would say there's other things that you can consider for dealing with the schools and the cost of schooling. One is if you work for a nonprofit for 10 years, then the nonprofit can discharge your debt. That's one a lot of people don't know about. So start a nonprofit.
For the debt of the college?
Mm-hmm. If you get federal loans and you've worked for a nonprofit for 10 years, you can discharge the school loan. Right?
Is that just a current thing, or?
It's always been the case.
Always been?
Yeah, I mean, since the 90s, as far as I know. Another thing that is interesting, you can play with this, most of the money that you receive will say that you can't settle the debt. Well, that's great, but what if grandma wants to? So grandma can always negotiate that debt. So an offer in compromise to say, I'll pay you 30% of the entire amount owed today if you'll discharge it. If they accept and receive that money, it's an offer in compromise, it's settled. You're no longer obligated on the rest of the debt. And some of these organizations are so big that they're not banks, so banks would have exceptions that would not allow this type of a trick to work, but they receive a check, they stamp it, they put it in. Article 9 of the UCC are checks, it's negotiable instruments. Negotiable instruments are contracts. When you endorse a check and there's limiting terms on that check that say, this is in full payment of my loan, or this is in this case, this is in full payment of my granddaughter's loan, that is a contract, enforceable. They've just settled that debt.
And it's not gonna show partially paid on the credit, right? It shows fully, it just shows a zero balance.
It can show partially paid, but you're not obligated. It's a settlement in full, and you can put that language on there. This is in full satisfaction. Okay, well now when they endorse it, they've just contractually agreed this is in full satisfaction.
I
So if
just
they
didn't know
put,
what that would do to your credit scores or.
yeah, well, and you can, the Fair Credit Reporting Act and all of the rules that come with that, there's other things that you can do. So you can challenge it, and if they haven't reduced it to a judgment, they have to remove it. And there's notice provisions and evidence provisions, and they have to comply with that. The Fair Credit Reporting Act is difficult to comply with. So if you put them on their heels, in most
They have a
cases,
time
you win.
period too, that
They have 30
to-
days, they
yeah.
have to respond to stuff. So you can play that game, you can be aggressive with it. The challenge is that if it's coming from a federal organization like the student aid, a federal student aid program, there's a student loan administrative court. It's a whole branch of government, and they owe you administrative due process, which basically means none. So if they decide that you circumvented their rules, regardless of the legalese behind it, they'll just find you in violation. And then they'll put you on a payment plan, and then you're gonna pay it off. Then you're doing what you're doing anyway, you're making your monthly payments. But in a lot of cases, you can negotiate those debts, even when they say, somebody else can negotiate those debts for you, even if they say you can't as the borrower. So I would deal with student loans in a different way. I don't see how using an investment property is tax efficient or anything like that for student loans.
Okay. Hopefully she gets free money.
Could you gift,
I'm manifesting
money if it was
lots
in
of
a trust?
scholarships.
I mean,
For
you're
that?
just trying to find money, right?
On a sale of
A
an
lot of people
asset,
borrow
we
against the
give some of those
property, so
proceeds.
we pay back,
Yeah.
you know.
Yeah, of course the schools that she picks are more than I.
You can use the funds to create a foundation, a private foundation, and you can use that to create a scholarship for your family.
Oh,
So there's some benefits in that methodology. So you're using a nonprofit foundation for that purpose. That would work.
okay.
That's a good point.
Yeah,
I'll be meeting with you soon, I'm sure.
I've been a recipient of some of those gifts.
Very good. Yeah.
So I know.
Alright.
I was talking
Do
to
you
Dan.
have more you wanna cover? Do you wanna open up to questions, or what?
We can open up to questions. I mean, it just gets really complex and different structures and things like that, right? I mean, this,
What kind of assets do you guys have now, or what are you eyeing? Have you invested yet? Do you have real estate?
Most of these are new, in here are new, yeah.
Okay. How many of you guys are real estate professionals in any capacity? Okay. Are you guys putting in the other two? Are you putting in your hours in real estate, or do you have any? Are you looking to get your first property?
Yeah, I have a finance background, so I've been doing, I'm doing a fix and flip right now.
Okay.
And I'm interested in, fix and hold and, duplex, fourplex. So that would be my question would be, I've watched lots of videos and talked to people here in Denver. I've been kind of last year talking to Amy about stuff, so just, like a duplex, exit strategy is really the opposite side of the entrance strategy. So you're going to find somebody who has a duplex or fourplex, if they have, right, you want to just carry some financing or something like that, because you want to minimize your equity investment, or you want to keep money that you can make upgrades or something like that. So that's my question would be, what is the steps as a lawyer, as an investor, that, hey, you found some properties, what do I need to ask the lawyer, what do I need to ask about even making a deal happen?
So the first thing I would do in your position is, assuming that you have a fairly good paying job, I would start using your real estate purchases to buy down your ordinary income from your job. And in order for you to do that, you're going to have to quite literally document your hours spent at the duplex. So you need to have qualifying hours in order to use the benefit of like a cost segregation analysis. On a duplex, it might not be worth doing, but as you continue to invest, when you buy a piece of real estate, the first year that you own it, you can accelerate all of that depreciation and use that to offset all of your income. And I would say that will boost your revenue from your real estate more than just about anything else that you do, just reducing your taxes, right? But in order for you to qualify specifically, you have to document how your hours are being used pretty intensely, right?
It has
For
to go
everybody,
a certain number of
right,
hours as
for
well.
everybody who has a real estate industry position, a real estate broker, appraiser, loan broker, attorney, we automatically qualify as being active in real estate with the material participation is one of the terms. So whenever we invest in real estate, we get to take that depreciation right away. But for you, you gotta quite literally have a journal documenting every hour. If you're thinking about it, if you're studying something, if you're inspecting something, if you're ordering materials, if you're installing materials, all of that you need to document.
that came down on, in like, what was that called? Because before it wasn't like that. It was like the Tax Act,
about
Tax Reform Act or whatever, 1986 or
8 years
something.
ago or something.
It's
Yeah.
pretty meticulous what is
Yeah.
required.
Yeah,
I remember when I was at my CPA,
yeah.
it came down.
And there's all kinds of your hours that are disqualified. So you know, if you're looking at real estate, that's not gonna actually be qualified.
How are you minimizing your tax gain on your flip?
Yeah, that's my next question is I haven't, you know, I've talked to people, and nobody's given me very good, and then you talk to your CPA, that's the advice.
Yeah,
I get,
so you can use things like the Augusta rule, I would look into that, where you get to, your business gets to rent back the property. You can create a family management corporation where you hire yourself or your kids to manage that asset on your behalf, and you can pay them a salary. So let's say you're gonna pay yourself 30 grand to manage the duplex. In order to clear that 30 grand, you as the owner of the duplex, you can now deduct that 1099 income for the 30 grand of salary to yourself, but then now you've got this corporation that made 30 grand. So the way you expense that out is if in your management capacity, if you've qualified as materially participating in the management of the asset, which can be either 100 hours or 500 hours or 750 hours, depending on your particular circumstance. You can then take that $30,000 and make a contribution to your pension, your IRA, your 401k, and quite literally create a $0 tax return for your family management corporation for the investment in your retirement. So you as owner essentially get to deduct the investment in your retirement account.
But
And
that's
how
if he
you
holds it, right? That's not if he sells it.
Right, and that
He's doing a fix and flip, so
Right,
you
on
got,
fix
you're
and
dealing
flip.
with short-term capital gains and,
It would be, income.
Yeah.
That's my understanding, yeah.
So
yeah, ordinary
1031,
income.
Income.
your 1031 is important. And with 1031s, keep in mind you can always do a reverse 1031. So you can buy a property before you sell the relinquished property. I see that a lot, but when you do that, you need to let your 1031 qualified third-party intermediary know that that's what you're up to, because they have to put things in the file to be able to identify that that's what you are using as the replacement property. So when you do sell the relinquished property, it rolls properly.
But you're in a partner with someone else, right?
Well, yeah, it's technically my property, so I mean, I'm starting this program, so this is hopefully one of multiple, but this is straightforward, just purchase last month, hoping to do 3 or 4 months worth of work and then sell it, you know, with, some 50K worth of profit and then share profit with that worker. So, in that case, it's just a regular income is my understanding. So, I said besides talk to your CPA, I had good advice, how do you minimize your, regular income for fix or flip? And there's other people in the community that are doing regular, I mean, they're doing $500,000 in profit, they're doing 10 properties a year, so they're making good money doing this, and they're under the same issue, they have, high income, so.
Yeah, so one of the things that comes to mind for you is, again, timing. And correct me if I'm wrong, because I haven't had this situation in a while, but for a while, there were restrictions on FHA buyers that said that the prior owner couldn't have owned it for shorter than
She probably never
X
went
number of
there.
years.
90 days.
90 days.
90 days, so you're gonna wanna hold it at least 90 days, so it looks like they've even loosened that from the last time I heard.
And you don't wanna transfer title in that 90 days either.
Yeah,
Cause that
exactly.
starts it all over.
Yeah, and then that, if you're a little familiar about, talk to a couple people on mortgage brokers, and obviously if you're taking 4 months to do a flip, then you've owned it more than 90 days.
Right.
But they were saying that is an issue if you buy something and then you wanna refinance it and you wanna keep it. They were saying that's the condition that FHA won't be more than what your purchase price was, so you basically have to, you did an upgrade to it, you have to, basically that's your thing. But there are some loans where if your goal was to fix and hold, if it's a personal property, then you could get an FHA loan with the improvement loan attached to it if you have a general contractor that's, attached to it, so that's something I'm looking at.
Yeah, so when you're looking as part of your flip, add to your portfolio that you can flip the paper, you can flip the deal as you're working on it. We like to leave a lot of work on the table for the next guy as kind of a strategy for our exit strategy.
Yeah.
And what that tells me is before you get to your finished product, start soliciting for that buyer and put it as a pocket listing, and you can time the purchase to still qualify so that the actual sale happens without violating those FHA rules, but you may have sold it the day you started.
Well, if you do conventional, then you don't have those rules, it's only with FHA financing.
Right, exactly. But what I'm saying is you can put the sale on paper and say, we're gonna agree to sell this to you the day you buy it, or even the day before you buy it.
Yeah, so you could find a buyer now
Right,
and be confident that you're gonna get the money.
so keep your ears open for people who would be interested in your exit, right? And then even if you haven't met your timeline for the hold, you can paper that deal well before you're ready to sell.
I don't deal a lot with
Grant though,
flips.
not our contract.
Well, even
zone.
a lot of your contracts, because if the contract comes in on your contract and you say it's gonna be a 120-day sale, that's just your
Yeah,
calendar,
that's true, yeah.
right? That creates an option contract. Your contracts are powerful. If you know how to use your contract as an option, there's a lot of power in that. Right? I've done that a lot. Back in about 2000, when Florida was going gangbusters, I was buying and selling properties on the basic contract, and we would put them under contract to build, and by the time the contract was due, the properties had doubled in value. And I would have $1,000 earnest money into the deal, and I would go down to Florida to close on the deal. We'd add sprinklers or something while we're down there, and at Kinko's, somebody at Kinko's was buying my deals before I ever even got it out of the printer. I had $1,000, so if you're buying at 80, selling at 165, and I wouldn't even make it out of the copy shop before it was sold.
Yeah.
$1,000 in.
Wow. I love those days.
But yeah, but that is just on the basic contract, right? Because it creates an option.
Yeah.
The earnest money is just an option contract.
Yep.
And for us, like my son in Washington State, and he got one property that he is renting out, and now he's looking for a second one. He just doesn't know if he wanna buy here, so we can kind of manage it, or if he wanna buy, say, in Seattle. So we are looking for next one.
So can you walk through, cause I was trying to explain, cause Title Y is currently, cause you had some questions around entity, right? Of how you should set that
Yeah.
up, did you wanna talk about those with them, or?
Yeah, we can, because like, if my son has a condo that he's renting out, and if something happened, let's say something going wrong, because he's also on a title with, condo where I live with my husband. So is it better to take him out of that title or the deed? You know, something goes wrong there in Washington, you know, I don't know, he got sued like by the,
So this is just general advice for anybody. You have 3 major creditors, whether you like it or not. They're all involuntary creditors. And it's kind of after death planning, after a crisis, after a collision with a car planning. IRS, Medicaid, and an involuntary creditor being whoever you may have gotten injured in a car accident, right? Those 3 creditors come out of the woodworks at death, or if they think that you have assets. And the way that law firms work is, especially contingency fee law firms, which are most of them, client calls in and says, I got this problem. Well, who are you suing? Boom, we're on the computer and we are looking up the net worth of the person you're suing before we even tell the person on the phone that we're taking the case. If it comes up and it says you're worth more than about $150,000, sure, I'll take that case. If it comes up as being you have no net worth, I have no interest. You're not getting sued. The point of that is, if your husband and your son are on title together, that is showing net worth to the internet, right? So now if I put in your son's name, I can see he's got net worth. That is a magnet for litigation. Getting him off of title so that you don't have involuntary creditors like slip and fall, slap suits, product liability suits, sexual harassment suits, all of those types. And we're not saying that they have any merit. I'm just saying you can get sued for just about anything in this country. And the biggest creditors are involuntary creditors, IRS and Medicaid. And they come out of the woodworks for everybody.
Well, and then if she were, when they pass, she also loses from the IRS perspective in that scenario, right? Because then he can't have step-up basis because he's on title.
Yes, you're right. Yeah, so if the son is on title and he's inheriting essentially by the other person's death, he doesn't get the step up in basis, which is huge. So the way the step up in basis works is when you buy the condo, let's say you pay $100,000 for it, you own it for, let's say, 30 years. And after 30 years, you've been forced to depreciate the property. So your cost basis for tax purposes is slowly dropping to zero. Then the property is, instead of being worth $100,000 after 30 years, it's worth $3 million. When your son sells that property, he gets taxed on $3 million. So the 0 to 100 is called recapture, and you can get nailed for the taxes there, and there's different rates for recapture. And then everything else would typically be long-term. Actually, would that be short-term capital gains? I don't know. Inheritance tax?
Not if he's on title, because if it's held joint tenancy.
You're right,
he's
it'd be
surviving.
long-term.
Yeah.
And you can get nailed with the taxes on that, all the way up to the $3 million. Versus if you put it in trust, for example, or if you held it in your own personal name, upon death, your heir would receive the asset at its value at the time of death. So $3 million would be his cost. Therefore, there would be 0 capital gains to be taxed, which is super cool because you have the ability to inherit up to $13 million per person. So you and your husband together would be $26 million. So if you had other money, like your stocks and your bonds worth $15 million, you can transfer that full $15 million. And because there was 0 capital gains on the real estate, none of that affects the inheritance exemption. Does that make sense?
Mm-hmm.
So you preserve the ability to transfer all of this other wealth as well as protecting the asset itself from taxation.
So he's looking to put the Washington property in the LLC?
So a couple things, like in Washington and Seattle, you're gonna have potential rent caps. So if I had to choose between investing in Seattle and Colorado, I would choose Colorado all day long.
This is why he wants to, this is why I am here.
Yeah, so Colorado's great because we have constitutional prohibitions on rent caps. The current legislature has been attempting their very best to figure out ways to reduce the rate at which rents are increasing, but they have a fundamental problem. The Colorado Constitution prohibits it. So until they're ready to completely amend the Constitution, landlords are pretty safe here. That's not the case in Seattle. As far as LLCs go, I differ from most attorneys when it comes to whether you should put your assets into an LLC. My number one concern is that the biggest crime happening that no one's talking about is title fraud.
I remember you talking
Yeah,
about this
she was
once.
at the one where you
Yeah.
talked about that.
So I object to the LLC because most people, they try to set up an LLC for the purpose of maintaining anonymity as a way of avoiding potential legal liability if they ever got sued, because it'd be so difficult to find out who the owner is. The problem with being difficult to find as the owner is that somebody can fake being the owner and they can steal your property, right? So I don't ever recommend owning any real estate in an LLC. There are some very rare exceptions, but in that case, I'm not going for anonymity. I'm actually gonna publish the heck out of who the beneficial interested parties are. And that way, title companies are put on notice on who they have to contact on public record before a sale is authorized.
So like, I remember you saying like going with a trust.
A trust, in my opinion, a solid trust is the best way to go. Because you can preserve the step up in basis, you can preserve your primary residence exemptions, you can preserve the $26 million inheritance exemption, all of that. And you still have creditor protections. Sometimes, in most cases, better than an LLC. With an LLC, you're forced to register with the state, tell the state certain information, and then comply with the corporate laws for the LLC. That's where people get stuck. There's probably 2,000 procedures that every LLC has to follow per year, and they're so nuanced. So the last corporation that I invalidated, the corporation had issued the owners stock. Well, in Colorado, you have to have a specific date format on a specific seal with a specific signature in order for the stock to have actually been issued. And then you also have to have a receipt for the issue. Because they didn't have any of that on their stock, they never issued stock. There is no ownership. So even though they tried to comply, they still didn't comply. They had the stock, and the lawyer that produced the stock had a seal. That's not a qualifying seal in Colorado. It's invalid. It's void by law.
Which is really hard. Most people, unless you're very experienced, aren't gonna set them up correctly, and then you're wasting your time.
Most people will try to buy it online and get a corporate setup, and even the lawyers, they subscribe to a central software service to print out the corporate documents. If they are not specific to Colorado's laws, they can be void. And then there's other procedures, like you have to have your annual meeting. If you didn't document your annual meeting, you violated the legal obligations of this corporate entity, and the court's just gonna ask you, look, if you're not gonna respect your corporation, why are we?
Don't you have to have meeting minutes?
You have to have meeting minutes, all of that stuff. If you
gotta have
commingle, if you use it as an
Operations
alter
agreement.
ego, you have to have an operations agreement. It becomes costly, it becomes procedurally overwhelming. Now, if you were making, $300,000 a year in your corporate organization, sure, LLCs can start to be a defensive shell. Once you start to recognize and honor the required procedures of a corporation, they can give you protections against certain liabilities. But when you're just buying a piece of real estate and putting it in an LLC, I would say almost with 100% certainty, you're not respecting the LLC, and the courts aren't gonna respect it either. It's just too costly. You have to spend, $10,000, $20,000 just in compliance to make sure you met all of the requirements. Whereas with a trust, there's no registration requirement, there's no procedural requirement, there's no annual meetings, there's no seals.
But
Once it's set up, it's
how do you put in
done.
a trust if you have few properties? Is it all going in one trust?
No, you can set up multiple trusts. And I do recommend that. If you set up a creditor protection trust and you put 3, 4, 5 assets in that, and then you feel like that's starting to make you have a little bit of anxiety about too much, and then you've got 3, 4, 5 more other properties, put those in a separate trust. Or you can put one per property. It's really how you want to address the risk. I generally will put up to $5 million into a trust, and then I recommend when you have the next $5 million, do another trust. And that's just my comfort, right? I don't feel like my tenants are gonna be able to sue me for the entirety of my insurance plus my umbrella, plus really substantively affect the value of my trust. So I do $5 million increments on mine.
You feel comfortable to put up to 5 million?
Yeah,
What's
and that's
your
just
overall
my
policy?
own tolerance. But a piece of that analysis is, I'm a lawyer. If you sue me, you gotta get through me first before you get to my asset. So you may not have that kind of confidence to rebuke an attack. So you may say, well, I only feel comfortable with 1 million per trust. Well, that changes the cost. You have to buy the trust to do the $1 million per trust. But that is a much more safe situation. So So,
So your cost to set up a trust is the documents when you set them up,
correct.
and then if you need to change something down the road. and
Yep, right.
rewrite it.
And with LLCs, so like a Delaware LLC, if you wanted to go that route, it's like $1,000 a year of just maintaining that form with Delaware. Colorado's like $50 a year. And you gotta take that into consideration, right? How much protection is that really giving you for $1,000 a year?
It'll slow you down at tax time too. If I have 6 different trusts and 9 different LLCs, an S corp, every year is an extension because it's very complex.
Yeah, and you start to get into a problem of finding a CPA that wants to handle your mess. Because when you start stacking these things, you go to the CPA, they don't necessarily know all of the operational
Yeah.
agreements. They have to read all of those operational agreements, charging you for that time, and they still don't feel comfortable. So they're probably gonna send it out to their lawyer to give an opinion about whether there's double taxation. It's really simple for me, because I just hand them, here's my trust, do that tax return, there's no other information. That's super simple. But when you've stacked it, LLC, holding company, trust, irrevocable trust, like you see these big plans, it creates a scenario where I wouldn't want to sign off on that if I was the CPA. There's way too much risk. Take your business someplace else.
Yeah, I have a team. So real estate is about building a team. You have to have a team. You know, you can't do this on, this is not a solo sport at all. You have to have your finance guy, your CPA, your attorneys, your vendors, right? This
Great
is,
lead-in to our happy hour next month.
Yeah.
Come get your team, they'll all be here.
it's very much a team sport, but it's figuring out how to structure it right from day one. And things will change down the road, but you have to have that good foundation.
Yes.
And
I think we can get Grant's contact information, but maybe just having a one-on-one with your son and him, like, you know,
Right,
like
I think
answer-
this is holding him up because like he would buy the property, but because like he doesn't have that foundation, he's just doesn't.
And most people are focused on the asset and the physical attributes of the asset, and they don't worry about the underlying tones of all the legalities and taxes and everything else that goes through it. And that's just as important, right? Because you work hard for that money, you wanna save the money, you know, you worked hard for that asset, you wanna protect that asset, you know? I mean, we've had some assets in my family 55 years. You know, we've gone through and restructured many times, and we've rehabbed that property many times too, you know? So,
And since we were talking about exit strategies, you can look at both corporations and trusts as a way to exit. So we were talking about like loopholes in the DST structure and a 1031 exchange where you're locked in for 5 years, but there's still this loophole you can get out with. If you're buying into one of these 1031 DSTs, or you're buying into a duplex with an LLC or a trust, sometimes you don't necessarily want to sell the asset. Sometimes you want to sell the entity.
yeah.
And in this situation, it would allow you more liquidity. So because you're locked in for 5 years, that whatever, let's say it's an LLC, that LLC has to stay in this investment until the end of the 5 years. But who the owner of the LLC is, no one cares. You can sell that. Right, so if you're locked in for 5 years and you need to sell the LLC, you can sell the LLC and get your liquidity back.
But even to do refinance, you have to like transfer property from LLC to your personal and transfer it.
You can. It depends on the income and the qualifications of the LLC or the organization that's applying for the loan. If the organization can qualify for the loan on its own, you don't have to transfer it out. But if it's requiring your personal guarantee and your personal credit score, then yeah, you're gonna have to transfer it out. You can transfer it out of even an irrevocable trust. You can transfer the asset out of, do the refinance and put it right back in. But what I'm getting at is when you're looking at an exit strategy, sometimes people don't want to go on record as having had a sale. Sometimes you, like in this case, it's an IRS determination. The entities in a DST with a 5-year hold period can't change. You can't have a new tenant, you can't have a new owner, you can't have a new lender. It's all locked. But if you entered as an LLC, you can sell who owns the LLC, and still the LLC stays in the fund, right? So you have, even though there's this 5-year term, a lot of people freak out, I don't wanna be locked in for 5 years. You're not. If you did invest with an LLC or you did invest with a trust, you can sell the control of the trust or the LLC, and those entities stay in the fund.
Wow.
Does that make sense?
That's long down here.
Yeah, okay.
No, but there's just other benefits of having a good structure. So if you entered in on the real estate and you had a proper structure, it can benefit you in other ways you're not even anticipating down the road. It can preserve exit strategies you wouldn't otherwise have. So for example, if I bought the property in my name Grant, I'm stuck. I can't get out of that 5-year hold until the 5 years is up.
So I'll get you his information.
Yeah,
Maybe
it's
have your
better
son
when they
come to Colorado for a ski trip on December 11th.
He's coming a week of Christmas.
Nice.
There you go.
Yeah, but
Alright.
maybe he can call or just.
Any other questions anyone has?
Well, thanks.
You're
All
welcome.
right. Well, thank you guys as
Thank
always
you for inviting us.
with all your intelligence and your fattiness. Appreciate it.
More fattiness than intelligence.